Let's take a few minutes to discuss some of the general clauses that can be found in almost any contract. Remember, these aren't necessarily specific to real estate contracts only. First, let's look at attorney's fees clauses. This clause is a provision in a contract which states that in the event of a contract-related lawsuit, the losing party will reimburse attorney's fees to the party that prevailed in the lawsuit. It may also require the losing party to provide reimbursement for other court costs and fees as well. Then there are arbitration clauses. These deal with the party's rights and options in the event of a legal dispute over a contract. Usually, they specify the actual process of arbitration that must be followed rather than a lawsuit. Choice of law and jurisdiction clauses are two clauses that address similar concerns. A choice of law clause establishes which state's law and rules will be utilized in the event there's a lawsuit related to the contract. A jurisdiction clause identifies the state and county where any contract-related lawsuit will take place. Another common clause is that of a contract price and payment schedule clause. This clause is fairly self-explanatory. It simply states the contract price and payment schedule. Escape clauses specify the conditions that would allow a party to back out of a contract without committing a breach. An escape clause, common in real estate transactions, is a 72-hour clause. The 72-hour clause allows the seller of a property to accept a conditional offer from the buyer associated with the contract while also keeping the property on the market. If the seller receives a competing offer from another buyer, they can invoke the 72-hour clause. The clause requires the buyer associated with the contract to purchase the property within a specified amount of time, which doesn't necessarily need to be 72 hours. If the initial buyer does not complete the purchase in the specified time limit, the offer is rejected and the competing offer becomes the primary offer. There are also what are known as exculpatory clauses. This clause is generally a provision in a contract that stipulates either one party is relieved of any blame or liability arising from the other party's wrongdoing, or one party, usually the one that drafted the agreement, is freed of all liability arising out of the performance or failure to perform that contract. There are also indemnity clauses. These clauses generally involve third-party losses or expenses. They'll state that any third party associated with a contract will cover certain losses or expenses incurred by another party under the contract. Indemnity clauses are often designed to protect parties under contract from liability and losses owed to third parties. Liquidated damages clauses generally set a dollar amount that would be paid if a certain type of breach of contract occurs. Merger and integration clauses state that a written contract is in its final form and it overrides any previous agreements or negotiations. A non-waiver clause is one that states that a party under a contract does not lose the right to enforce contractual obligations even if that party forgives another party's non-compliance with the contract. A severability clause states that a contract is still valid even if one of the provisions of the contract is rendered invalid. Severability clauses are intended to protect the integrity of the contract. A time is of the essence clause relates to particular dates by which specific tasks, such as inspections or repairs, must be completed. Where time is of the essence is indicated, the necessity to meet deadlines becomes incredibly important, and it's imperative to know the exact target dates. Under this clause, the completion date or time is critical and time itself has high value. The failure to meet a performance deadline can be determined to be a breach of contract. In addition to being grounds for a breach, time is of the essence provisions can affect payments under a contract as well. If a contract is silent on the time for performance of work, the courts will infer a reasonable time for performance. As a real estate agent, you'll constantly be dealing with contracts, and it's important to understand the general clauses found in most contracts and be able to explain them to your clients.